the topic of discussion. So with that, I will advise that this will probably be a 30-minute session, so we can have a more interactive Q&A session. Sorry, I'm just trying to upload this. Okay. Okay. At present, sorry. At present, there is, I think we will all agree that the current trend is for businesses to collect collect and process personal data from most of its customers in the course of running the operations of the business. Personal data refers to the process of personal data refers to information that can identify an individual sometimes in the most private aspects. As such, it is crucial for data processors and controllers to always seek to comply with legislative framework in place that governs data protection, in this case in Uganda. Article 27 of our Constitution introduces the right to privacy. The right to privacy, stating that no person shall be subjected to interference with the privacy of their person's home, correspondence, communication, or other property. As such, the right to privacy is a constitutional right for all people. In Uganda, we have the National Information Technology Authority, NITAU, which is designated as the National Data Protection Authority that also maintains data protection. The Data Protection Register, in this session, we'll keep referring to it as the registrar, that lists every institution, person, or public body that collects or processes personal data. Personal data includes the storing, sharing, utilization of data. In Uganda, data processors and controllers are subject to specific obligations that are outlined in the Data Protection and Privacy Act of 2019. In this session, we'll keep referring to that as the Act. The Act along the Act is the Data Protection and Privacy Regulations of 2021. These laws mirror the UK Data Protection Act of 1998, which imposes certain obligations on data processors, on processors of personal data. The Act places an obligation on data processors to ensure that they hold and process personal data in a manner that does not infringe on the privacy of a data subject. The data subject is the owner, you and me, the owners of data that is being collected. Data processors are also required to ensure that data is complete, accurate, and up to date. Furthermore, they only process relevant data. So they should choose and apply and upload into the public space data that is relevant for the purpose that it was collected. Then the data processors are also required to maintain security measures for the protection of people's data. With regard to those who control data processing, these are also known as data controllers. The law requires such a person or an institution or body collecting or processing personal data to register with NITA Uganda for inclusion on the register. The different purposes for the personal data to be collected or processed should always be detailed in the application for registration. Suffice to mention that this register is a public record that can be accessed by anybody. So if one wanted to know if the person they are sharing their data with is operating lawfully, they can always cross-check with the data register. On the topic of privacy notices, those processing and controlling personal data are required to provide certain information in clear and plain language to those whose personal data is being processed, the ones I refer to as data subject. This is meant to ensure that data subjects are aware of why their data is collected, how it is used, and to whom it is being shared. This information is given to data subject by way of a notice, which is usually referred to as a privacy notice. In other cases, a privacy statement or a data protection notice. It's if I can clarify, highlight at this point, when it comes to collecting or processing data of children, this can only be carried out with the prior consent of the parent or guardian or other person that has the authority to make decisions on behalf of the child. That's very, very important to organizations that collect data. Because oftentimes you go to a hospital and then they'll just ask you for the child's details. And I'm not sure I have seen any part that indicates that the parental consent has been sought. They just ask you for this information and it's filled in and that's it. So that's a bit irregular. A privacy notice, to understand for those maybe who don't know what it is. Privacy notice is a statement that describes how, for example, a website or any business or organization collects, uses, stores, and shares personal information. The core theme that runs through data protection laws, whether it's the UK or EU GDPR, the General Data Protection Regulation, it's a call on organizations to be upfront and open about how personal information is collected and what it's being used for. Oftentimes, people confuse a privacy notice with a privacy policy. A privacy notice is, while they seem similar, they're actually different and they serve different purposes. Privacy notice is a publicly accessible document created by the organization for potential data subjects to access, or even the data subjects onboarded to access and know information that relates to them. Privacy notices provide individuals with information about how their personal data is processed as required by the Act. Privacy notices are, as Anita quite rightfully mentioned, they are designed to promote transparency and enable individuals to understand and exercise their data protection rights. Because if you have a right, you need to know how you can enforce it. You need to know when it is violated. So that is what you expect to find in a privacy notice. A privacy policy, on the other hand, is typically an internal document intended, for example, to guide employees on their responsibilities for ensuring, employers rather, on their responsibilities for ensuring compliance with data protection laws. In this case, in the Ugandan context, that's the Act. Privacy policies outline the organization's practices and procedures for handling personal data and typically not accessible to the public. It is crucial for organizations that collect any amount of personal information to have information, for example, from the staff, to have a privacy policy. And also people who want to deal with the business, for example, should be able to, people who want to deal with the business should be able to see this. Most times you'll find this as a website footer that links you to the privacy policy of a company if you need to access it. The key aspects of the Ugandan law of privacy of our laws is the right accorded to, with regard to privacy notices, is the right accorded to data subjects to be given information on where their personal data is collected directly. Sorry. The Act affords data subjects the right to be given information in cases where, for example, data is collected from the data subject. This can be cases where the data owner voluntarily provides their information to the controller. There is specific law relating to that. Then on the other side on the flip side of it is where the information is not obtained from the data subject. You still have a right to be informed. For example, this is where data is accessed from third parties or other available sources sources to the data controller or data processors. The salient features of a privacy notice, of just an overview. This is relation to ease of understanding. When you read a privacy notice, it has to be as concise, transparent, intelligible, and easy. For example, for the form, if there is a form, it's easy for the person to understand it. The language is typically expected to be as plain as possible, but without taking away from the context. Then also there is a call to avoid technical terms or legal jargon, which the layperson, for example, might find difficult to understand. Some data protection terminology like profiling, processors, controllers, anything that can easily be misunderstood, for example, by the person, is asked to be broken down or explained as much as possible for the person to understand. Then when it comes to complex businesses, the more complex one's business is, the more detail a notice will typically be expected to be, so that any aspects that could lead to conflict or breach are addressed at the outset. This then brings me to the information that is required to be included in a privacy notice. Regardless of the methods used for data collection, at a minimum, a privacy notice should include the identity and contact details of the data controller. It should give contact details of the data controller as required by the Act, wherein the data controller is mandated to register with the Data Protection Unit, the office. The application, including the details of their names, contact, and addresses, are also provided. If a data controller has a representative, their details should also be provided. The other aspect of the notice is contact details for the data protection officer. The head of an institution typically designates the person who is the data protection officer responsible for ensuring compliance with the Act. Compliance in this case being compliance to the extent that the data subject is accorded transparent and accurate information as to their rights. The DPO, that's the data protection officer, is usually an expert on the principles of the data protection and privacy. And this is usually the primary point of contact for data subjects. There is also, the privacy notice should also specify the purpose for which data is collected and processed. Along with the legal basis for processing that data, there is the Act is very express on this. Data controllers and processors should identify the specific lawful basis for why they are processing this data. Aspects of consent, whether it is in respect of performance of a contract and their interest, for example, in the data, whether public interest or legitimate interest have got to be provided. The privacy notice should also indicate how long the data will be retained as required by the Act. If there is no fixed time frame, data controllers and processors are required to outline the criteria to be used to determine how long they intend to keep their data. Many people do not know that once you submit your data, you have to know for how long they are going to be holding your data for. It's not, I don't think there are many people who go back and recall their data, for example. Data, people generally have rights in relation to the use of their data. This includes the right to access, the right to prevent processing of personal data, the right to prevent processing of, for example, personal data for direct marketing by some organizations, the rights in relation to, for example, automated decision-making, the algorithms, like you give your data and then the algorithm mechanism in place just decides how they will use that data when dealing with you or other people. Subjects also have the right to rectify and call for erasure of their personal data. These rights are, for lawyers here, these rights are in sections 24 to 28 of the Act. The privacy notice has got to reflect accurately what the rights are and how that data subject can take steps to enforce their rights. They have to know. Because once you are empowered, you then can hold the data controller to task as to the misuse of your data. Data subjects also have got to be informed in the notice about the right to lodge a complaint with the Data Protection and Privacy Office in Uganda, for example. The privacy notice is required to provide contact information and instructions on how to lodge a complaint. The data subjects in Uganda have a right to lodge a complaint with NITA in the event of an alleged infringement of their data rights. Most people don't know this. They share data online, their images are abused or misused, and people don't know where to go. As I mentioned earlier, the data subject always has a right to withdraw consent. So when data is being processed, the consent, since the consent of the data subject is required, the privacy notice should explain how individuals can withdraw their consent. The Act empowers and has that aspect with regard to the notices. Then the most, I think, from our practice experience is with regard to data sharing. A privacy notice is required to specify the organizations and categories of organization with whom your data will be shared. This is in the Act sections 24. If the data will be transferred, for example, to another jurisdiction or a third party, maybe an entity that is a third party contract with the organization that one is sharing their data to, this has got to be disclosed. Whether or not data will be transferred to another country or international organization needs to be informed. I think we will all agree that it's only fair for someone to know that the data that you're giving company X will be shared to their affiliate or holding company somewhere else or its business partners. And then you make a decision, one is able to make a decision or whether or not they want that to happen. With regard to personal data subjects are required. I need to be informed that maybe, for example, there will be automated decision making in the process of application of that data in the future. So, and the consequences of such automated decisions need to be explained. There are times when algorithms, for example, can adversely affect somebody. Like if you have indicated your age bracket, you could easily be cut out of certain opportunities. So you need to know earlier on whether algorithm application would come into place with regard to your data. The Act dwells a lot into the issue of a lawful basis for processing data. Where data processing relies on lawful basis, for example, what is the reason, the legal reason for the data processor or entity to collect your data? The law has guidelines on what constitutes legitimate interest, what constitutes lawful basis, and those different aspects are the basis for the organization. The organization has got to comply and select the one that actually applies. It is a narrow definition provision. So anything that is outside that ambit will be considered unlawful. People need to be informed of the lawful basis that an entity is relying upon. If an organization relies on the aspect of legitimate interest as its lawful basis, this needs to be explained to the data subject. There should be no surprises about how someone's data is being used. If the company, for example, is looking into wealth screening, research, marketing, etc., the data owner has got to know. So while most people would think that it's just a compliance thing. I will get a privacy notice. I can even go and download one for myself. And you think that nobody will ever look at it. You can be sure that anyone who intends to comply will go to it. So it had better be very, very well drafted. Even the regulator will be looking at you. If they get a complaint against you through NITA, their NITA office, they will come for you. So the future is such that prospective clients and partners should scrutinize their privacy policy. In some cases, even your business, people who intend to do business with you, will look at your privacy notice as part of their due diligence exercise. So this privacy notice is no longer a light matter. It's a matter that any organization that collects data has got to look at and make sure that they are in line and operating within the confines of the law. So somebody would ask, why do I need a privacy notice if consent has been given on some tricky tick box? In Uganda, as Anita indicated, entities that collect personal data are required to create and circulate a privacy notice. There are therefore several reasons why a privacy notice is essential, just for the business, besides the legal compliance, because you need to understand why it's there. Data is an asset right now. It's a lot, and liability cases are beginning to show up when misuse arises. So what the privacy notice does is it enables individuals to understand what data is being collected, why it is being collected, how it will be used, how long it will be retained. This is a question of transparency. Everybody now wants to deal with a transparent entity. This then in turn empowers individuals to make informed decisions as to whether or not they want to share their data with you. Like I said, there is the aspect of compliance with law that is there, but the key thing here is transparency. Then also we touch the issue of data subjects' rights. Privacy notice provides individuals with information to exercise their rights. Their rights are in the Act, that's section 24 to 28, which allows individuals to challenge or request changes to the way their personal data is used. By clearly outlining these rights in the privacy notice, organizations therefore facilitate the exercise of these privileges by data subject. I'll give an example or part of a holding in a recent case. That was Lubega Utanaziba versus MTN Uganda. In that case, the plaintiff sued MTN for violating his rights to privacy when they released his call records without his consent. The court held that, and this is important for our purposes, there is a fiduciary relationship between the company, the defendant in this case, and its customers, like the plaintiff, by which the defendant holds highly personal, confidential, and private information of its clients in trust and confidence. It follows that the defendant should not release its client's information to anybody that seeks that information from it. I'm not sure whether this matter has gone on appeal or not, but what we are taking away from this is the courts are now enforcing that right to privacy. Now, what happens if, for example, a company does not comply? There are penalties. There for offenses which are aimed at ensuring compliance. These include unlawfully obtaining or disclosing personal data, unlawfully unlawful destruction, deletion, concealment, or even alteration of personal data. And then in some cases, this data is sold to other third parties without the data owner's knowledge. So the penalties currently imposed against corporations, and they range from imprisonment to fines and even levies on gross income. So people have got to be mindful, or data collectors and companies that are processing people's data have got to be mindful of this. So then the question then becomes, what is the role of the lawyers? How can we lawyers come in to help in this space? Data protection, privacy and data protection are really interrelated concepts. They involve very complex statutory, regulatory, and common law requirements and restriction. Privacy and data breaches, whether accidental or intentional, are frequent front page news, for example, in other jurisdictions that are known to damage a corporation's reputation. So there are also now there are cases coming up about class actions against entities that have violated people's privacy and data. So when drafting that privacy notice, an organization will be able to ensure that their statutory requirements are complied with to minimize the penalties that are being put up. And then also future liability issues can be addressed and averted in time or clearly. I think there is no question in anyone's mind that a well-drafted privacy notice would play a very crucial role for any organization seeking that continues to get personal data from the public. People need to be able to exercise their right to determine how their data is used, control when they want it out there or when they want to pull it down. And then any organization, by adhering to these concepts, should be able to demonstrate the commitment to protect personal data and build trust with data subjects. I'm sorry if this seemed a bit too technical, but anyone who is interested in like a one-on-one on this can always contact us, and then we can discuss this further or help them with the drafting of their privacy notice or ensuring compliance with data protection laws. Thank you. And I think we are still in time. Thank you for this. Over to you, Anita.
Okay, thank you so much for that very educative presentation. The reviews in the chat are really, really very positive. I believe you are able to read them. I am going to go straight to the questions. Okay, I'll begin with the questions in the Q&A. Question 1, someone asked, okay, can the privacy notice be translated in the local language, for instance, Luganda, or it should strictly be in English? Over to you.
We have not had the experience of translating one into Luganda. So unless if the information provided is capable of being translated into Luganda, just like any other form, we should be able to translate, use maybe like an experienced translator to make sure that the information in English is adequately translated. Like, for example, we have the mutation forms in Uganda. I'm sure that can be worked out. That can be worked out. But from a legal perspective, it's not a requirement for it to be translated. Most times it's in English.
Okay, all right, thank you so much. I'll move on to the next question. Someone asked, I would like to find out if a privacy notice is supposed to be an independent document or if it's embedded in the consent form presented to the data subject before data is collected.
It's separate. The privacy notice is separate. It's accessible as a standalone, and where once you consent, the information given is indicated, and then at the bottom of it, you still confirm that you have read and understood the terms of the data collection and processing. So it is an independent standalone document.
Okay, thank you very much. There are a couple of questions coming in. I would ask Grace to respond to the questions that are specifically about the office, not this webinar. There is a question. Someone is asking, does PDPO, okay, members that comply with the PDPO, do they get a certificate or something to prove their adherence to PDPO requirements and regulations? Grace, over to you.
Thank you, Anita. Hello, everyone. My name is Grace Kenganzi, Manager PR and International Affairs. Yes, when you comply, when you register with the PDPO, you get a certificate. Of course, that is, it expires it expires annually. So every time you renew, then yeah, we give you a certificate.
Okay, thank you so much, Grace. Okay, another question for you, Paulsen. Someone is asking, supposing a national security agency demands some data about my staff, do I have to first inform the staff? Supposing they don't give me that opportunity to contact the staff, over to you.
By law, there is information that can be shared without the data owner's consent. But still, out of courtesy, the data controller would make it known to the person. For example, if someone has committed a financial crime or an online crime, and maybe the FIA is investigating the matter and reaches out to the data owner, aided by, for example, a court order, that is information that the data controller cannot refuse to give. They would have to get it. For example, we know that security agencies get court orders during the course of investigation and access personal data.
Okay, thank you so much. Another question is it necessary to have contacts of the data protection officer in the privacy notice? Over to you.
Yeah. Yes, you would have to. The more information you give, let's remember the key thing is transparency. So the more information you make available to data subjects, the more comfort they will have in dealing with you. So if you're secure, if you put your primary data processors, controllers, and security officials have made known to the people, it works out to your advantage.
Okay. All right. Thank you very much. Someone is asking, does an individual data collector require a privacy notice?
Yes, they would. The law it's not just about organization, it talks about people who collect and process.
Okay, thank you very much. Another question coming in is, would you recommend that a privacy notice be made and attached to any service level agreement in order to bring it to the attention of a customer?
In what context, I wonder? I'm trying to understand. The service level agreement, let's say you're dealing with a third party vendor or contractor.
I think
And
so.
you're going,
Yeah,
and you're going to collect personal data from them. Because let's understand that the spirit of the law is, for as long as you are receiving data that is perceived to be personal or private, then you have to make sure you comply. I don't know, I'm trying to understand the SLA requirement. Maybe the question can be reworded.
Maybe I can unmute Simon. I can unmute him so that he's able to ask his question and make it clear.
Okay.
Just give me a second. I'm trying to get Simon to unmute him so that he's able to speak. Simon, are you able to speak? Simon, can you hear me?
Yes, I can hear you.
Okay, kindly ask your question.
Thank you so much, Senior Counsel, for the presentation. My name is Simon Odomoi. I work with the CRB, and we get data from institutions. Of course, in our service level agreements between us and these institutions, there is always a requirement for consent from the subjects. But the question is, as these institutions are giving us this data, would it be necessary for us to draw their attention to this privacy notice by making it part of the agreements that we sign with the institutions? That's the question I was asking.
In the anticipation that some of this information will be private?
Yes.
Then to that extent, but you see the notice, the privacy notice, as long as you can make it available before the data is obtained, that is fine. But usually you will have to duplicate it on another another platform. For example, our website or other ways that the people dealing with you are able to access it. So if your choice of operation is at the back, that works, but just make sure that it's out there.
Okay, thank you.
Okay, thank you so much, Simon and Lacey. I am going to read the next question. Someone asks, if an employee fills in a medical insurance form with information of spouse and children's information, how do we handle that? Because the spouse and children may not have given consent and they may not have read the privacy notice.
So there is information, for example, in this case, there is information that, for example, if you're giving information about your child and your parent, that the law covers that, like legally you're covered, you're capable of, because you've made an informed decision to share this information to the extent that you've understood that it will be protected. Now, with regard to your spouse, who is not going to be able to participate in this, at that stage, Anita, I haven't experienced where you need to get consent online, but usually, as long as the adult has given this information and it's not of a nature that's going to prejudice the other party, I think it should be okay.
Okay, thank you so much. I hope I've been answered. Okay, the next question to you is, would you recommend the privacy notice to have all categories of personal data used or in storage?
The privacy notice should detail the kind of, remember the legal basis that we talked about. In that comes the
Yes.
obligation to be clear as to what kind of data you hope to collect. So your notice has got to have that information readily available. The kind of data you seek to collect, and also the purpose.
Okay, right, thank you so much. I'll read another question here. In context of NGOs, at times collaborating partners or lead partners provide for collection of data using tools controlled by them. What is the fate of the data collector in case such data violates privacy, although consent has been sought?
So in that case, clearly, the data controller is not, for example, the NGO in country. Because if the tools are being, whoever controls the tools is the controller. So that is the person who should put on the register as the data controller, because it has to echo the reality with regard to the operations of the business and how this data is processed. So if it is external, then the external party has got to be named as the data controller.
Okay, thank you so much. I'll move on. We have a lot of questions that are still coming here. Yes, okay. Another question is about, someone is asking, must every organization have a privacy notice, especially for those of us who collect M&E data from other organizations?
Unfortunately, the law is such that as long as you're collecting people's data, you have to comply.
Okay. All right, I'll continue and go to the next question. Our organization conducts trainings from time to time, and we conduct pre and post-training surveys. We also have the participants sign consent forms for us to use their photos, videos, audios, or name, etc. At what point should we explain or present the privacy notice to the participant?
In that case, because this is specific, this is like carved out, it's specific. In that case, the organization would have to come up with a privacy policy with regard to these trainings, and that's a bit different because this is internal. So they would have to create an internal privacy policy with regard to information and images shared or received.
Yes.
It doesn't have, can't be, it's not the type that is covered in the blanket notice. So this type of organization would have to create a privacy policy, which is then shared beforehand with the third party before they contract with you.
Okay. All right, thank you so much. Someone was asking for your contact. We will be able to share it later, of course,
Yes,
with your
please.
permission.
Yes, please.
Okay, and then there's a question on Gazette notices. I think I'll just address this to Grace to answer it, and then we'll continue with our questions. Any update on Gazette notices as highlighted in the data protection and privacy regulations? Specifically, they are asking regulation 15.2, 34 and 31. Over to you, Grace.
All right, thank you, Anita. These are still in draft form. We will alert you as soon as they are completed, as soon as they're published.
Okay, thank you so much, Grace. I hope the person who asked that question has been answered. Lacey, over to you again. We have a question here. Someone is asking, what is the basis and guideline of updating a privacy notice?
Privacy notice, like any other business or information tool, is capable of change. So as and when the data aspects of an entity change, the notice should be amended to conform or to comply with the data collection mechanism or needs in place at the prevailing time. So you just go back, redraft it, adjust it to the needs at the time, and then upload it.
Okay, thank you so much. I'll move to some questions that came in through the chat section. Someone was asking, if we get data from patients to trace their history, do we really need to have a privacy policy for the patients?
You need to have a privacy notice, clearly, especially the medical field. Yes, you do.
Okay, thank you so much. Someone is asking for data capture via systems. How can privacy notice consent be done to users? An example he gives is patients in case of healthcare setting. Over to you. I hope that's clear.
You see, typically, what's happening in the medical world now is people are have available for signature on the form that you now have attached to the form, or the back of the form, the data privacy notice. So because if you're getting the information about somebody, once they give that information, they will be able to read the next aspects, which is their privacy notice, the notice that you have in place. So on top of it being online, you actually have one that is readily available at the time of getting the information.
Okay, thank you so much. Another question we have here, someone is giving a scenario: security agencies storming into offices and just carrying out computers and files without consent. So they are asking, do they have a right to do that? Or they need to notice the organizations prior?
You see, if crime is committed, that is a totally different scenario, and there are remedial or a grievance settlement mechanism that come in place. If the person feels that their information or data was unlawfully obtained, then they can take action against the offending officers. But it's a very tricky situation when a crime is believed to have been committed.
Okay, thank you very much. I can see we are almost coming to midday, and I think at this time I am going to invite Grace to give closing remarks. For those whose questions we've not been able to answer, please keep the conversation flowing on our social media platforms. And of course, our email, you can reach out to us through info@pdpo.go.ug. I'll type it in the chat in case you have any questions. I will also share Lacey's contact with this presentation so that you're able to reach out to her. I'm going to share a link in the chat. Kindly give us feedback on today's presentation. Blaise, we want to thank you so much for today's presentation. As you could see, it was really very engaging and very educative. At this point, I'm going to hand over to Grace to give us closing remarks. Over to you, Grace.
All right, thank you, Anita, and thank you, Blaise, for that wonderful presentation and for sharing your knowledge with us. And thank you, everyone, for attending this month's webinar. In case you have an organization or you're a data collector or you keep personal data, you store it in any way and you're not registered with the Personal Data Protection Office, just to encourage you, please register so you're compliant. You can register at www.pdpo.go.ug. And yeah, just remember that we are available to answer any questions on all our social media platforms and our portal, and that we'll have such monthly conversations. So we hope to see you next month. We always have these conversations the last Thursday of the month. So we hope we'll see you then. Thank you so much, Blaise. Thank you, everyone, for coming. Have a good afternoon.
Thank you too. Thanks for having me.
Okay, thank you. Bye.